You're watching Bill on Bankruptcy. I'm Lee Pacchia. I'm joined now, as always, by Bloomberg News bankruptcy columnist Bill Rochelle. Be sure to go and read his daily bankruptcy column. It's available on BloombergLaw.com, and it's also on the Bloomberg Terminal, and it is fantastic. Bill, thanks for joining us today.
Good day.
The biggest item of the week, of course, is the biggest event for the summer, that is the insolvency of Detroit's situation. They, of course, filed a Chapter 9 bankruptcy. Bill, do you have any observations about Detroit and the entire situation that haven't already been written up or discussed ad nauseum in the press?
Well, I guess so. You know, Detroit's bankruptcy is not like any other in this country, and that's not just a matter of size. Detroit is far sicker than any other city that has gone into bankruptcy. Indeed, absent a state bailout of some sort, to some degree, not fully, of course, I'm thinking that the outcome will also not be like any other municipal bankruptcy we have seen so far. Now, New York City back in the 1970s, when it was near bankruptcy, was sick, but New York was not nearly so sick as Detroit. In New York's circumstance, everybody lent a hand to keep the city out of bankruptcy, and I mean everybody. The unions and the pension funds, everybody helped out. Pension funds even bought city debt when nobody else would. In Detroit, we have pretty much the opposite. Everybody is saying, don't tread on me. You've got bondholders saying we need to be paid in full, and you have pensioners saying our pensions can't be touched. Detroit is also different from some others in terms of the revenue stream. For instance, with Jefferson County, Alabama, a $4 billion odd bankruptcy, the problem there that led to bankruptcy was a state court ruling that a city income tax, or I shouldn't say income, a wage tax, was unconstitutional. That cut off a mainstream of resources and ended or put the city into bankruptcy. The Detroit situation is different because those citizens are already about as fully taxed as anybody in this country
Very
ought
high
to
taxes.
be. That's exactly right. So you can't solve their problems or pay off old creditors by raising taxes. Also, by the way, with many municipalities, part of the reorganization is in, shall we say, trimming municipal budgets. But in Detroit, it's really, I think, the opposite. Their main problem in that city is a lack of adequate city services. So if anything, to make Detroit an attractive place in which to live, you're going to have to improve things like police, fire, and sanitation, and that doesn't come cheap. You also have to do something about the massive amounts of abandoned real estate. That stuff has got to come down. It has to be demolished because otherwise it's just sitting there as a breeding ground for crime, and there is no way you can have a police department large enough to police a city that is mostly or largely vacant. And of course, all of that costs money. It is conceivable, and I think very realistic, that Detroit will have a turnaround. Look at New York, for instance. Some of the worst neighborhoods on earth used to be Harlem, the South Bronx, and Bedford-Stuyvesant. But guess what? Those neighborhoods are undergoing a remarkable renaissance. In part, it's due to the fact that with effective policing in New York, those are now safe neighborhoods, not dangerous neighborhoods. Detroit, by contrast, is one of the most dangerous places on God's earth. If, therefore, you can solve the problem of city services, deliver them effectively, get rid of the destroyed real estate, then I think you will have a circumstance very much like in New York, where private developers will come in, perhaps buying up at one time dozens of acres of land in Detroit for redevelopment. But realistically, that can't be done until you have a city that is supplying basic municipal services. If what happens here is that the city's meager revenue has to be diverted to the payment of old debt, I'm not sure the city is going to be able to deliver effective city services. And in that case, I don't know whether there ever can be a renaissance in Detroit. I guess what this comes down to, Lee, is the fact that if you ignore a problem for too long, it becomes really quite critical and perhaps nearly beyond salvation. And I suppose also, if you look at the bottom line, what it may mean is that without some help from the state in terms of servicing the old debt, the poor old city of Detroit just may have to, after bankruptcy, devote most of its revenue to the provision of basic civil services that citizens of all cities in this country are entitled to receive.
Bill, what about a federal bailout? It sounds like that's pretty much what has to happen here. Either the state or the federal government is going to have to pony up some money.
Well, you know, the federal government thumbed its nose at New York City.
Famously.
Famously, a great headline, as we all remember. I don't think that's realistic because that really is a moral time bomb. If the feds step in for Detroit, then why not any other troubled city in America? I just don't see that happening. That, however, will present a political problem for our president, I do believe, but time will tell.
Time will tell. And we have a Judge of the Week. This week, it's New York's newest bankruptcy judge, Sean Lane, who will preside over the August 15th confirmation hearing where American Airlines intends on having its reorg plan approved. Do you expect Judge Lane will have much trouble in signing a confirmation order?
Well, probably not, judging by the few objections that were filed to confirmation of the plan. The biggest monetary issues really have to do with whether or not there should be a default rate on some of the aircraft bonds or whether some of the bondholders are entitled to a make-whole premium. But on that make-whole issue, the Circuit Court in New York is going to be deciding that probably in the next few weeks. Although I think confirmation of the plan doesn't present a whole lot of a big problem, the biggest hurdle to jump will be what's called HSR clearance, which is to say the Justice Department has got to give permission for the two airlines, US Air and AMR, to merge. And that very well may not happen by the 15th of August. But eventually, I suppose these pieces are going to come together, and the United States will be left with very few major airlines.
And Bill, of course, we sat down earlier today with Lewis Kruger, CRO of ResCap. He's overseeing a large bankruptcy in Chapter 11. Had some interesting comments on examiners filing reports under seal. Let's take a look at what he said. It's really been interesting to look at the year-long examiner stint that took place in this case. $83 million in fees. The report was filed after about a year, and it was filed under seal. This is something that we've seen in a lot of other Chapter 11 cases. My question to you, do you have any views on whether courts are too often allowing parties to file these reports under seal?
I think in the case of ResCap, it was a useful thing for the court to do because it gave us an opportunity to complete negotiations, which ultimately led to a planned support agreement, which is the premise for why my optimism that this case will come to a conclusion in November. But I think had the examiner's report come out, I think it would have just set back the process. Maybe not changed the ultimately outcome, but I think just set back the time frames.
Lou, what about beyond ResCap in other cases? Do you have any feelings about whether sealing is being used too much or too little?
I think it depends. Obviously, it goes from case to case, but I think it probably is not being used too frequently. I think judges make intelligent decisions about when it's useful for the case to seal things. And I recognize that you spent all this money, there's a public desire to know what's in that report. But I also find that over the course of the years, examiners' reports, with very few exceptions, are sort of very, very balanced. There's something in it for everyone, so it's not always clear that there is a winner and a loser from the results of the examiner's report.
Well, Lou, beyond examiners' reports, do you have any sense whether bankruptcy judges are too easily grant sealing orders in bankruptcy cases?
Oh, no, I think they do not. I think that Judge Glenn, in the case of ResCap, was certainly very concerned about the sealing order, put strict time frames on it and strict events that needed to be accomplished. And if they weren't accomplished, the examiner's report would be released. So I don't think courts are being too lenient with respect to them.
And Bill, we conclude, as always, on our advance sheet section where we look at important bankruptcy decisions that have just come out. This week we're looking at one from the Circuit Courts of Appeal in Philadelphia and another from the Circuit Courts of Appeal in San Francisco. What are those courts teaching us?
Well, first off, out of the Third Circuit in Philadelphia, we have a case called Lazy Days RV Center. This was an opinion by Circuit Judge Thomas Hardiman. This is a wonderful opinion because it reverses what I think was a bad opinion in September of 2012 from a district judge in New Jersey. Here is what went down. The bankruptcy judge confirmed a Chapter 11 case. After the case was over, there were 2 lawsuits in a state court far away disagreeing over what the judge meant in one of his orders during the Chapter 11 case. So one of the parties came to the bankruptcy judge and said, "Please, Judge, tell us what you meant," and he obligingly did. It went up on appeal, and a district judge said, "Nope, that's wrong, shouldn't do it." The new court, that is to say the state court, should decide what the bankruptcy judge previously meant. Went to the circuit court, and Judge Hardiman reversed resoundingly. This is very important because the decision by Judge Hardiman in the Lazy Days case gives bankruptcy courts a green light later on to go back, even if there is a state court lawsuit pending, to explain what it was that they meant. The second case is from the Ninth Circuit in San Francisco. This is a split decision with a majority written by Circuit Judge Susan Graber. This case, by the way, creates a split of circuits. What this case is all about is the question of whether there is a presumption of deceit. If somebody files a bankruptcy petition and then doesn't disclose, there is a pending lawsuit that could bring in money. Circuit Judge Graber said in her opinion that if the bankrupt, after bankruptcy, goes back and revises the bankruptcy papers to include a listing of this lawsuit, then that presumption of deceit no longer exists. This is an issue, I think, that will eventually wind its way to the U.S. Supreme Court. I have a feeling, not just yet, not in this case, but it will if we live long enough.
All right, Bill, thanks for that. That's Bloomberg News bankruptcy columnist Bill Rochelle. If you'd like to learn more about the cases or issues we just discussed, be sure to go check out Bill's report. It's available on BloombergLaw.com, and it's also on the Bloomberg Terminal. That's what we have for this week. I'm Lee Pacchia. Thanks for watching.